Good afternoon, everyone. Welcome to the show, The Politically Social, and I'm your host, Afia. Today, we have with us attorney Ryan Gills. Attorney Gills represented the victim in the case against General William Cooley. Mr. Gills has nearly 2 decades of experience and is a recognized national victims' rights expert who represents survivors of crime in connection with the investigation and prosecution of their assailants. Under his leadership, the law firm Arnold&Potter represented dozens of sexual assault survivors in both civilian and military proceedings pro bono. He's on the board of the National Crime Victim Law Institute, the honorary board of Protect Our Defenders, and is the former board chair of the Network for Victim Recovery of DC. Welcome, Ryan.
Thanks for having me.
My first question is, General Cooley was convicted, but he could definitely avoid prison and was not dishonorably discharged. What message does this convey?
I think for most survivors, the message is more about the conviction than the sentence itself. It's certainly a disappointing sentence in the sense that it feels like a slap on the wrist. The reality of the case is that the ultimate conviction in the case was not a sexual assault, in the sense that it was not a rape. It was an unwanted kiss. That doesn't make it any less of a crime, but it's important to understand exactly what he was convicted of. But I know from my experience that most survivors who come forward and decide they want to prosecute a case and go to the criminal justice system to seek justice, the sentence is important, but really secondary. And really the most important thing is for the survivor to be heard, and for ultimately the defendant, the accused, the rapist to be held accountable.
Okay, but from a legal standpoint, how do you think how do you think the general avoided more severe penalties that could have been imposed, such as dismissal, a reduction in the rank, or even up to 7 years in prison?
Yeah, I think the reality is the nature. It's certainly disappointing. I'm not trying to justify the sentence, but in terms of what the conviction was for, I think it would be fair to say that similar convictions in similar cases likely would have resulted in the same type of sentence. Again, because while the conduct at issue in that case involved a number of different allegations of assault, the conviction itself was for unwanted kissing. And so the idea of 7 years in prison for unwanted kissing, I think would probably be a pretty clear violation of the Eighth Amendment. But that's just my personal opinion with respect to the case. I do understand the concern that survivors have in the fact that cases generally do not result in meaningful convictions and lengthy sentences. We certainly don't want to diminish that as an important issue and something that we should focus on, particularly in the military justice system, which currently does not have sentencing guidelines for rape.
Right. Now, this is also a first court-martial trial of a general in the branch's 75-year history. But recently, we've been hearing a lot about Me Too in the military. What is your take on that?
Yeah, I think it's interesting. So I think the Me Too movement on the civilian side actually comes after really a reckoning of sexual assault and sexual violence in the military. It's important to remember that back in the early 1990s, the tailhook scandal, there was a tremendous amount of attention at that time of the sexual harassment and sexual violence, and lots of discussion back then on Capitol Hill about changes to be made. And the reality is that there was a lot of talk and not a lot of meaningful action. And then when you get to the early 2012, 2013 timeframe, there was again a significant focus on the military justice system and on the thousands of soldiers, sailors, Marines who are assaulted every year while serving their country. So I think that focus and that attention existed well before this most recent iteration of the Me Too movement. I do think that it's an important message that those at the senior level are being held accountable for their actions. I think it does reflect progress in the military and in the military justice system. Certainly not a perfect system and a lot of work to do, and we need to keep our eye on the ball, because in my experience, in the military justice system, if you're not focusing on this issue, it will come back again. It is a constant, there's a constant need to focus and make sure that we are supporting survivors and holding predators accountable.
Right, and the victim and her family has our team's full support and sympathy. I cannot even imagine the emotional trauma she has to deal with. But from a legal standpoint, how does the victim feel about this conviction?
I think that, I mean, look, here's the thing that happens in these cases, right? It's a very long journey from the time of initial reporting and making a decision to report, to going through the investigation process, to having to answer questions along the way and be accused of lying, to be accused of manufacturing information or trying to catch a case or some other super rape. The idea of the survivor coming forward and then making something up is something that we see. It's this great myth that's out there, and I think survivors who confront that often go through tremendous emotional challenges and difficulties along the way. And I don't think that was any different for the victim in this case. I think that there were moments along the way where she legitimately questioned whether it was worth it, the damage that it was doing to herself personally, to her family. I think it made it very difficult for her to set this aside, to compartmentalize it. And so I think it was very challenging, and it was very difficult for her. But ultimately, at the end of the day, she secured a conviction. And I think she felt at the end supported by the prosecutors who brought the case. She was deeply appreciative of their efforts, of their professionalism. And so I think was she disappointed in the sentence? Yeah, she was disappointed in the sentence. Would she have liked to have seen convictions on some of the other charges? Absolutely. But the way she would describe it is that she did her job. She stood up for others. And in doing so, allowed the justice system to send a powerful message to men in power.
Right, and then that brings me to my next question. Colonel Matthew Neal said, if this result influenced just one survivor to know that his or her attacker's rank or status would not prevent them from being held accountable, that's a win for the US and the military justice system. Do you share those beliefs?
I do. I think a lot of respect for Colonel Neal, and I think he was one of the prosecutors in the case, and I have a lot of respect for those who are in the military and are trying to do the right thing, right? There is a lot of things wrong with the military justice system. Some of those things remain. Many of them are improving, but there are a lot of excellent women and men in the military justice system who are supporting survivors, who believe survivors, and who are doing their best to prosecute these cases.
Right. Now, from purely a legal standpoint, General Cooley was charged with 3 specifications, and as we discussed, he was convicted of only one, which was forcibly kissing his sister-in-law. But he was not charged of pushing her against the car door and inappropriately touching her. What do you think were legal grounds for this? Because on the charge sheet, he was charged of all the 3 offenses. I mean, on what legal basis were those entirely dismissed?
Well, I think it's slightly inaccurate to say he wasn't charged. That activity was part and parcel of the specifications, right? So I think it's fair to say that while there were not individual charges for each act along the way, there were Article 120 charges, sexual offense related charges that were part of that case. And I think I don't have any concerns with the decisions the prosecutors made in this case, in terms of what they charged and what they didn't charge. There are often strategic reasons. There are burden of proof reasons, right? I mean, it's important to remember that this is a country where you need to prove guilt beyond a reasonable doubt. That is incredibly difficult to do in a sexual assault case, especially in this environment. And so the prosecutors are making decisions along the way as to what they think are the best charges to bring and to focus on.
Right. And the victim at one point said the price for peace in my extended family was my silence, and that was too high a price to pay. This
Yeah.
is a very sad reality, and we've seen that victims don't open up. And then we also witness cases like that of Vanessa Gullin. Now,
Mhm.
as an attorney that represented the victim, in your opinion, what are some of the steps that can be taken to make, victims feel safer?
Yeah. So I think there's a lot of steps, and some of them exist. A lot of it is about there are existing resources in the military that provide support for sexual assault survivors. There are advocates, there are health initiatives. There are a lot of resources out there and available. I do have some concerns about the quality of not so much the victims advocates, but the availability and the quality of mental health care in the military for survivors is extremely important, right? And I also think that continuing to believe and support survivors needs to be more than just a PowerPoint presentation that then results in some scoffing after the fact when everyone goes to a bar and says everything, is baloney and this is all made up. I think there needs to be real, meaningful leadership at the junior enlisted and even at the junior officer level, providing support for those in the military to know that they can be believed, they can be supported, and that they have a chance for justice.
Right. Um, what does Article 120 of the Uniform Code of Military Justice exactly say, like in a nutshell?
Well, it's multiple. There are multiple provisions within Article 120, but if you think about it on the civilian side, it's basically the statute that sets out the criminal charges, right? So you have various types of sexual offenses. You could have the penetrative rape, for example. You could have abusive sexual contact. You could have taking pictures of someone without their knowledge or permission. So there's a variety of charges within Article 120 that one can bring are somewhat similar to the way you would charge in a civilian case.
Right. You in the past have said, hopefully this will not be as difficult for the next survivor. What were some of the challenges that your legal team and the victim faced during the proceedings?
Yeah, I think a lot of what happens for survivors who do come forward is that they immediately feel like they're on trial, that they've done something wrong, that they're lying, or that their behaviors, which may seem odd, can't be explained, and so they're just making this up, right? And I think that can be a very difficult experience for a survivor. Rape is about power, right? It's about taking power. It's not about sex, it's about power, taking power from someone else who doesn't want to give it to you. And so when you then enter a military justice system where you again feel powerless, it can be very challenging and it can be very alienating and it can impact your life in ways that you don't anticipate. And even if you have the best care in the world and a supportive family, as the victim did in the Cooley case, it's a struggle. And if you are in any way listening or paying attention to what's happening in your case, you're constantly wondering why it's taking so long. Why are they asking me these questions? And why are they asking me to provide all of this information? And so it can be very difficult. And then when you get to the trial itself, actually testifying is a very challenging experience. You're confronting in court, in person, the person who has done the most heinous thing in the world to you. And you know what the truth is. And yet you sit there to be judged, it feels like, by others who were not in the room, who were not there, right? And so I think it's very difficult. And even if you do, and it's unlikely because the conviction rate is so low, but even if you do secure a conviction, the reality is that what happened to you doesn't change, right? And so you have to live with that for the rest of your life. And so there are many challenges along the way, as we discussed before. There are certainly resources out there. The presence of victims advocates and victims legal counsel are significant improvements in the experience of survivors. We know that they can significantly improve that experience, but it is not a picnic by any stretch.
Do you think the Air Force was committed enough to ensure that justice is done?
In this case, yes, I do. I think that they, I think that with COVID, there was a challenge in sort of moving things forward. And I think there was a frustration in the timing, but I can't blame the Air Force lawyers for that, right? So I think that they were committed to doing the right thing. They put senior people on this matter who were committed to doing the right thing and devoted a lot of resources and time to it. And ultimately, let the trier of fact, in this case, the judge, ultimately render a verdict. So I think in this case, yes, I'm not, by any stretch, I'm not here to champion and say that the Air Force or any of the military branches are always perfect. There's always room for improvement. But as I mentioned before, there are definitely good women and men in the military seeking to do the right thing.
Right. And as you've mentioned in the past, it takes immense courage for the victims to come out. And it's an emotional trauma, but what kind of support is really available for them?
Yeah, so I think, what I do in my job, right? So I'm a pro bono. This is not what I do to pay the bills, right? So this is work that I've done for over a decade, and my colleagues as well, where we are victims' legal counsel. And our job as lawyers is to go in to advocate on behalf of the victim. And that most often comes up in the context of protecting the victim's privacy, protecting the victim's therapy and medical records, for example, explaining the proceeding to them, and giving them power in the process so that they know that there's someone, right, who represents them, because the prosecutor doesn't represent the victim in a criminal trial. In the military or in the civilian world, they have no ethical obligation to the victim. Their job is to represent justice. And of course, defense attorney's job is to represent the defendant. So who's there to represent the victim? That's the victim's legal counsel. And then victim advocates serve a somewhat similar role where they'll provide support and a voice and potentially resources to be supportive of a victim. So those are things that are available to active duty soldiers, sailors, and Marines and their military dependents. Now, they're not available to all civilians, which is one of the reasons that Arnold&Potter takes on these cases, is so that we try to fill that gap in services for civilians. But it remains true today that there are hundreds of civilians every day who are victims of sexual assault by members of the military who are not represented. And that's a problem. It's something I'm hoping that we will be able to address in Congress. But at the end of the day, it's something that we need to make sure every victim has a right, not just a right to, but is afforded as part of this part of the military justice system.
Mm-hmm. And I know a lot of things here are confidential, but can you shed some light on the type of evidence that the defense team came up with and why those were not credible?
Well, so I'll speak. I think it's best to speak generally about these cases, right? So I think that typically what happens in a sexual assault, and there's many differences, right? There are alcohol related and drug related sexual offenses, and they're of a type. There are spousal related sexual offenses for those who are interpersonal violence. The rare rate is the stranger assault, right? Like in the bushes type of assault. Those are the fewest and far between. So there are some differences between them, but for the most part, what you typically see defense counsel do in these cases is to point out what they would consider to be what is often called counterintuitive behavior. Actions by a survivor that don't make sense. For example, a survivor might go into a police interview and might laugh. And people think, well, how could a survivor laugh in the midst of giving a statement? She's obviously lying. Well, of course, anyone who knows anything about nerves or anxiety and the like, that's a perfectly natural reaction and response, right? There's also minimizing and other well-known things that happen with sexual assault survivors who try to blame themselves for the behavior. So defense attorneys will typically seize on that behavior and distort it and try to use those rape myths that I described before, right? That no means yes, that women are just trying to catch a case, that it was just a big misunderstanding. All of these things that are out there in the broader society, not just in the military, but throughout society, that defense counsel will seize upon. And those are the things that they typically bring up in these cases. Oftentimes, like I said, there will be alcohol or drugs involved. They'll bring up ideas around blackouts and misunderstandings as it relates to alcohol inducement and things of that nature. So there's no one way in which these cases are defended by the accused, but it certainly is one of those examples I described before where survivors feel that they are actually the ones on trial.
Right. Ryan, what is your take on the supposed written admissions of guilt by General Cooley? Like when he sent some emails to the victim and then later deleted those.
Yeah. So I think that it's difficult to answer that without being there at the trial. And this is one of the things that I caution everyone when they start to follow a trial in the paper, is that it's difficult to know all of the facts and all of the nuances, right? So the reality is that there were different charges related to different specific conduct. And what he admitted to or didn't admit to had apparently a bearing on the trier of fact as to what the court found when they made their findings, right? And so while it's an admission of guilt, I think that's an example where that's what the prosecution is arguing and they're doing their job in making that argument. The court obviously determined that it did not have a belief beyond a reasonable doubt that those other charges were actually admitted to by General Cooley. And at the end of the day, that's the trier of fact's job. And that's one of the challenges of these cases is that, it's not just, do I believe her? That's not the standard. The standard isn't, do I believe her? The standard is, am I sure beyond a reasonable doubt that each element of this offense has been proven by the government? And that's the job of the trier of fact. And so it's not surprising to me that in cases like this, there are these split verdicts where you get some conviction, but not on all of the charges.
Right. And when the judge said that General Cooley shall face a public reprimand, what do you think that exactly means in a court martial?
So a reprimand is a letter of reprimand in his file, right? And it ultimately can have, I can't speak to this with specificity. I mean, ultimately this has to be determined by the military, but I think it has a potential impact on his career. I wouldn't want to speculate as to what that impact is, but it has a potential impact on his career, on his retirement, on his benefits, and so forth. And look, no matter what happens in that sentence, it doesn't change the fact of what happened to the survivor. And she still has to go through that. And so at the end of the day, focusing on whether or not that letter of reprimand results in him losing his rank or being demoted or any of those things that the military might be able to do. I think for her and speaking with her, she's in a great place because she knows that she's done what she would say is her job. Standing up. Not that every survivor is in a position to do that, right? This is certainly not meant to be critical of those who don't come forward. I completely understand the challenges that it takes to come forward, and some survivors are just never going to be in that position, and that's okay. But for her, it was important for her to stand up, and so the fact that this letter of reprimand is issued is certainly helpful, and I wouldn't want to pretend that it was all that the survivor wanted. But at the end of the day, I think she believes justice was done.
Right. You've talked about many changes over the last decade and how, those have made it less daunting for victims of sexual misconduct by military personnel to come forward. These changes include policy developments that better support accusers. Can you shed some more light on what kind of policy developments are these?
Yes, so it's better to support the victims, right? So the accusers, exactly. So look, when I first started to take these cases on, so 2012 timeframe, there were a number of, just by way of example, one of the very first victim that I ever represented was allegedly sexually assaulted by 4 members of the Navy football team. She was a midshipman, and it was in the media. It was high profile, and it was at a time when there was also significant attention on sexual assault and sexual violence in the military, because the annual reports were showing tens of thousands of soldiers, sailors, and Marines who were victims of sexual assault and sexual harassment. And so the civilian world got a view of how she was treated in that process pre-trial. She went through 3 days of pre-trial cross-examination. And she was treated horribly throughout that process. And I think that was really eye-opening and led to some significant changes. It led to, for example, the creation of the Victims Legal Counsel program that I've mentioned. The elimination of the ability of the convening authority, which is the general or admiral typically, who makes decisions about prosecuting cases, remove their authority to reduce or eliminate sentences for these types of offenses. Provided significant support in the areas of victim advocacy. Revised the laws related to protection of psychotherapy records. Whereas before it was a matter of routine for a victim's psychotherapy records to be turned over at least to the judge for review. Changes in the law have made that extremely rare these days. Significant improvements in that space. And there's been dozens of other enhancements along the way, providing the victim with additional information, additional notices, the right to be made aware of available civilian options. So there's a lot out there. Right, so there's a lot out there. There's more to do. No question, there's more to do. But there's been some significant enhancements over time that have improved the process. One of the challenges that we see in working on these cases is that victims are not always made aware of those resources, or are aware and don't fully trust them because they have seen that they have failed others in the past. Survivors are typically hypervigilant. They look to see how other survivors are treated. And they look to see how the justice system performs. And when it fails to perform in a way that's fair or adequate, they will take notice of that, and it will make it less likely for them to come forward. And only when every survivor feels supported enough to make that decision and is not making it out of fear, will we have a justice system that's truly meeting its obligations to its military members.
Right. Thank you so much, Ryan, for joining us. This was very, very, very helpful. Thank you again.
Absolutely.
We're off recording. Ryan, I also wanted to mention that we are a nonprofit organization, and 2 of us are attorneys. So we do assist other attorneys a lot. And then about 2 of our members were journalists in the military in the past. So Great. We resonate with this type of stuff. So anytime you need any help, in the pro bono matters from our team, we'd be there.
Great. Awesome. That's so nice to hear. Thanks for the work you do.
Thank you so much. Thanks.
All right, you two, be safe.